A very good afternoon to all present here. My name is Nikita. In today's video, I'll be discussing the Bharatiya Nagarik Suraksha Sanhita 2023, hereinafter referred to as the BNSS, in contrast to the Code of Criminal Procedure 1973, hereinafter referred to as the CRPC. So in this video, I'll be covering the notable changes to the CRPC which have been incorporated in the Bharatiya Nagarik Suraksha Sanhita 2023. So, as we all know that the Code of Criminal Procedure 1973, it regulated the procedure for arrest, investigation, inquiry and trial of offences under the Indian Penal Code 1860 and any other law governing the criminal offences. So, it provided a comprehensive mechanism for conducting the trials in a criminal case. The Bharatiya Nagarik Suraksha Sanhita 2023, which aimed to replace the existing CRPC, received the assent of the President on 25th of December 2023 and it came into force on 1st of July 2024. Now let us study the framework of the two acts. As we know that the Code of Criminal Procedure 1973 had 484 sections and 37 chapters. On the other hand, the BNSS has 531 sections and 39 chapters. Now let us see the deleted provisions of the CRPC, that is to say that these provisions have not been included in the newly enacted BNSS 2023. Some of the definitions which are deleted are as follows. Section 2 clause F, which defined India, has now been deleted. Section 2 clause K, which defined metropolitan area. Section 2 clause T, which defined prescribed, has now been deleted. Now let us see the provisions which have been deleted. That is to say, Section 8, which talked about the metropolitan areas. Section 10, which dealt with Assistant Sessions Judge. Section 16, which talked about courts of metropolitan magistrate. Section 17, which talked about the chief metropolitan magistrate and the courts of additional chief metropolitan magistrate. Section 18, which talked about the special metropolitan magistrates. Section 27, which talked about the jurisdiction in case of juveniles. Section 144A, which talked about the power to prohibit carrying arms in procession or mass drill or mass training with arms. Section 153, which dealt with inspection of weights and measures. Section 355, which provided for metropolitan magistrate judgment. And Section 404, which dealt with statement by metropolitan magistrate of the grounds of his decision to be considered by the High Court. Now let us see the newly introduced provisions in the Bharatiya Nagarik Suraksha Sanhita 2023. So, 5 new definitions have been added in Section 2, which are as follows. Section 2, subsection 1, clause A defines audio-video electronic means. Section 2, subsection 1, clause B defines bail. Section 2, subsection 1, clause D defined bail bond. Section 2, subsection 1, clause E defines bond. And Section 2, subsection 1, clause I defines electronic communication. Now let us see the provisions which have been added. That is to say, Section 86, which deals with identification and attachment of property of proclaimed person. Section 105, which talks about the recording of search and seizure through audio-video electronic means. Section 107, which talks about attachment, forfeiture or restoration of property. Section 172, which talks about persons bound to confirm the lawful directions of the police. Section 336, which talks about evidence of public servants, experts, police officer in certain cases. Section 356, which dealt with inquiry, trial or judgment in absence of a proclaimed offender. Section 398, which talks about the witness protection scheme. Section 472, which talks about mercy petition in death sentence cases. And Section 530, which talks about trials and proceedings to be held in electronic mode. So these are the new provisions which have been introduced in the BNSS 2023. Now let us see the changes which have been introduced. So, Section 1 of the CRPC, which provided short title, extent and commencement, it corresponds to Section 1 of the BNSS, which deals with short title, extent and commencement. And it says that this act may be called as the Bharatiya Nagarik Suraksha Sanhita 2023. According to Section 1, subsection 2 of the BNSS, the provisions of Sanhita other than those relating to chapters 9, 11 and 12 shall not apply to the state of Nagaland and to the tribal areas. So we can see that chapter 9, 11 and 12 have been mentioned instead of chapters 8, 10 and 11. So chapter 9 deals with the security for keeping the peace and for good behavior. Chapter 11 deals with the maintenance of public order and tranquility, and chapter 12 deals with the preventive action of the police. Now let us see the change which has been incorporated in section 2 of the BNSS. See, section 2 of the BNSS has been expanded to introduce new definitions for key terms such as audio video electronic means, bail, bail bond, bond and electronic communication. The definition of the victim as provided in section 2, subsection 1, clause Y has been changed by eliminating the requirement of the accused person being formally charged. An explanation has been added to the definition of investigation, which states that in case any provisions of a special act is inconsistent with the provisions of BNSS, the provision of special act shall prevail. Now let us study the newly introduced definition. Section 2, subsection 1, clause A defines audio video electronic means, which states that it shall include the use of any communication device for the purposes of video conferencing, recording of process of identification, search and seizure or evidence, transmission of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. Section 2, subsection 1, clause B defines bail, which means release of a person accused of or suspected of commission of an offence from the custody of a law upon certain conditions imposed by an officer or court on execution by such person of a bond or a bail bond. Section 2, subsection 1, clause D defines bail bond, which means an undertaking for release with surety. Section 2, subsection 1, clause E defines bond, which basically means a personal bond or an undertaking for release without surety. Section 2, subsection 1, clause I defines electronic communication, and it means the communication of any written, verbal, pictorial information or video content transmitted or transferred whether from one person to another or from one device to another or from a person to a device or from a device to a person by means of an electronic device including a telephone, mobile phone or other wireless telecommunication device or a computer or audio video player or camera or any other electronic device or electronic form as may be specified by notification by the central government. Now let us see the change which has been introduced in the definition of victim. See, earlier the term victim was defined under section 2 clause WA of the CRPC, but now the term victim has been defined under section 2 subsection 1 clause Y. So, victim means a person who has suffered any loss or injury caused by reason of act or omission of the accused person and includes the guardian or legal heir of such victim. So, the requirement of accused person being charged has been removed now. So, as a result of introduction of few definitions and deletion of few definitions, now there has been rearrangement of definitions as provided in section 2 of the BNSS. Now let us see the major changes which have been introduced in the BNSS as compared to the CRPC. So, Section 21 of the CRPC, which provided for special executive magistrates, it corresponds to Section 15 of the BNSS. So, according to Section 15 of the BNSS, the state government may appoint executive magistrates or any police officer not below the rank of superintendent of police or equivalent to be known as the special executive magistrates for a particular area or for the performance of particular functions. So, a change which we can see is that the addition of the words any police officer not below the rank of superintendent of police or equivalent have been added in section 15 subsection 1 of the BNSS, which were not present in section 21 of the CRPC. Section 24 of the CRPC, which provides for the provision of public prosecutor, it corresponds to Section 18 of the BNSS. Section 24 subsection 1 of the CRPC, it corresponds to Section 18 of the BNSS, and it provides that for every High Court, the central government or the state government shall, after consultation with the High Court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such court any prosecution, appeal or other proceeding on behalf of the central government or the state government as the case may be. Now, a change has been brought in section 18 subsection 1 of the BNSS, which is in the form of addition of a proviso, which states that for the National Capital Territory of Delhi, the central government shall, after consultation with the High Court of Delhi, appoint public prosecutor or additional public prosecutor for the purposes of this subsection. So, this proviso, which has been added in section 18 subsection 1 of the BNSS, was not present in section 24 of the CRPC. Section 25 of the CRPC, which talks about the assistant public prosecutor, it corresponds to section 19 of the BNSS. So, according to section 19 subsection 3 of the BNSS, where no assistant public prosecutor is available for the purposes of any particular case, the district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case after giving notice of 14 days to the state government. So, section 19 subsection 3 of the BNSS, it stipulates a new requirement of giving notice of 14 days to the state government, which was not mentioned in section 25 of the CRPC. Section 25A of the CRPC, which provides for Directorate of Prosecution, it corresponds to section 20 of the BNSS. So, section 25A subsection 1 of the CRPC, it corresponds to section 20 subsection 1 clause A of the BNSS, and it provides that the state government may establish a Directorate of Prosecution in the state, which consists of Director of Prosecution and Deputy Director of Prosecution. Now, according to section 20 subsection 1 clause B, state government may establish a district directorate of prosecution in every district, which consists of deputy directors and assistant directors of prosecution. So, apart from the establishment of a Directorate of Prosecution, there is a District Directorate of Prosecution which has been established under section 20 of the BNSS. Now, let us see the eligibility criteria regarding the appointment of Director of Prosecution, Deputy Director of Prosecution and Assistant Director of Prosecution. So, according to section 20 subsection 2 clause A, a person shall be eligible to be appointed as a Director of Prosecution or a Deputy Director of Prosecution if he has been in practice as an advocate for not less than 15 years or is or has been a sessions judge. So we can see that earlier under section 25A subsection 2 of the CRPC, the requirement of practice was not less than 10 years, but now it has been increased to 15 years. Also, the words is or has been a sessions judge, they have been added in section 20 subsection 2 clause A, which were earlier not mentioned in section 25A subsection 2 of the CRPC. A person shall be eligible to be appointed as an assistant director of prosecution if he has been in practice as an advocate for not less than 7 years or has been a magistrate of the first class. Now let us discuss the roles and responsibilities of the Director of Prosecution, Deputy Director of Prosecution and Assistant Director of Prosecution, which have been provided under section 20 subsection 7, subsection 8 and subsection 9 respectively. So, according to section 20 subsection 7 of the BNSS, the Director of Prosecution shall be monitoring the cases in which the offences are punishable for 10 years or more, or with life imprisonment or with death, to expedite the proceedings and to give an opinion on filing of appeals. Section 20 subsection 8 provides that the power and the function of Deputy Director of Prosecution shall be to scrutinize the police report and monitor the cases in which the offences are punishable for 7 years or more but less than 10 years for ensuring their expeditious disposal. Section 20 subsection 9 provides that the functions of Assistant Director of Prosecution shall be to monitor the cases in which the offences are punishable for less than 7 years. Section 28 of the CRPC, which provided for sentences which the High Court and the Sessions Judge may pass, it corresponds to Section 22 of the BNSS. So, according to Section 28 subsection 3, an Assistant Sessions Judge may pass any sentence authorized by law except a sentence of death or imprisonment for life or imprisonment for a term exceeding 10 years. Now, with the advent of section 22 of the BNSS, the power of the Assistant Sessions Judge to pass any sentence has now been abolished. Now, section 29 of the CRPC, which provides for sentences which the magistrate may pass, it corresponds to section 23 of the BNSS. Now, there has been a change in the amount of fine which the magistrate of the first class or the magistrate of second class can impose. So, earlier, according to section 29 subsection 2 of the CRPC, the Court of Magistrate of the first class may pass a sentence of fine not exceeding 10,000. But now, as per 23 subsection 2 of the BNSS, it can pass a sentence of fine not exceeding rupees 50,000. So, the amount of fine has been increased from rupees 10,000 to rupees 50,000, and also he can impose community service as a form of punishment. According to section 29 subsection 3 of the CRPC, the Court of Magistrate of the second class may pass a sentence of fine not exceeding rupees 5,000. But now, as per section 23 subsection 3 of the BNSS, the Court of Judicial Magistrate of the second class may pass a sentence of fine not exceeding rupees 10,000 or both, or of community service. So here also the amount of fine has been increased from rupees 5,000 to 10,000 respectively. Also, the magistrate of the first class and second class, they have been empowered to impose community service as a form of punishment. So, community service shall mean the work which the court may order the convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. Now let us see section 31 of the CRPC, which provides for sentence in case of conviction of several offences at one trial, which corresponds to section 25 of the BNSS. So, according to section 25 of the BNSS, the court shall, considering the gravity of the offences, order such punishments to run concurrently or consecutively. So we can see that the term consecutively has been added in section 25 subsection 1 of the BNSS. However, there was no such term in section 31 subsection 1 of the CRPC. Also, the maximum amount of punishment has been increased from 14 years to 20 years as mentioned in section 25 subsection 2 clause A of the BNSS. Now, section 41 of the CRPC, which provides for when police may arrest without warrant, and section 41A of the CRPC, which provides for notice of appearance before a police officer, it corresponds to section 35 of the BNSS. And a new subsection 7 has been added to section 35, which states that no arrest shall be made without prior permission of the officer not below the rank of Deputy Superintendent of Police in cases of an offence which is punishable for imprisonment of less than 3 years and such person is infirm or is above the age of 60 years. Section 41B of the CRPC, which provides for procedure of arrest and duties of officer making an arrest, it corresponds to section 36 of the BNSS. So, section 41B clause C required that the information of arrest be given to the relative or a friend, but section 36 of the BNSS, that is section 36 clause C of the BNSS, required that the information of arrest be given to the relative or a friend or any other person named by such person. So we can see that the words any other person have been added in section 36 clause C of the BNSS, which were not mentioned in section 41B of the CRPC. Section 41C, which talks about the control room at district, it corresponds to section 37 of the BNSS. So we can see that there is a change in the marginal heading. So section 41C talks about control room at district and section 37 talks about the designated police officer. Now we can see that a clause B has been added to section 37, which provides that the state government shall designate a police officer in every district and in every police station who is not below the rank of Assistant Sub-Inspector of Police, and he shall be responsible for maintaining the information about the names and addresses of the persons arrested, the nature of the offence with which he is charged, and which shall be prominently displayed in any manner, including in the digital mode, in every police station and at the district headquarters. Section 43 of the CRPC, which provides for arrest by a private person and the procedure on such arrest, it corresponds to section 40 of the BNSS. So, in section 40 subsection 1 of the BNSS, there has been addition of words but within 6 hours from such arrest. Now, there was no such time frame as mentioned in section 43 subsection 1 of the CRPC, but now under section 40 subsection 1 of the BNSS, a time frame of 6 hours has been made. Section 46, which talks about arrest how made, it corresponds to section 43 of the BNSS. Now, section 43 subsection 3, it provides for the provision of use of handcuffs, and this is a newly inserted subsection which states that the police officer may, keeping in view the nature and the gravity of the offence, use handcuff while effecting the arrest of a person who is a habitual repeat offender, who escaped from custody, who has committed the offence of organized crime, the offence of terrorist act, drug-related crime, or the offence of illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offences against the children, and the offences against the state. Section 50A of the CRPC, which talks about the obligation of the person making arrest to inform about the arrest to a nominated person, it corresponds to Section 48 of the BNSS. So, according to Section 48 of the BNSS, every police officer or other person who is making an arrest under this Sanhita shall forthwith give the information regarding such arrest and the place where the arrested person is being held to any of his relatives, friends, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to the designated police officer in the district. So we can see that the words also to the designated police officer in the district have been added in the latter part of Section 48 subsection 1 of the BNSS, which were not mentioned in Section 50A of the CRPC. Section 52 of the CRPC, which provides for power to seize offensive weapons, it corresponds to Section 50 of the BNSS. So, according to Section 50 of the BNSS, the police officer or other person who is making an arrest under this Sanhita may, immediately after the arrest is made, take from such person the offensive weapons. So, we can see that the words immediately after the arrest is made are added in Section 50 of the BNSS, and these words, that is to say immediately after the arrest is made, they were not present in Section 52 of the CRPC. Section 53 of the CRPC, which talks about the examination of accused by a medical practitioner at the request of a police officer, it corresponds to Section 51 of the BNSS. So, according to Section 53 of the CRPC, the examination of accused by medical practitioner can be acted at the request of a police officer not below the rank of sub-inspector. But in this case, that is in the case of Section 51 of the BNSS, it can be acted at the request of any police officer. So there has been a change, that is to say that earlier he could have acted at the request of a police officer not below the rank of sub-inspector, but now he can act on the request of any police officer as mentioned under Section 51 of the BNSS. Also, Section 51 subsection 3 provides that any registered medical practitioner shall, without any delay, forward the examination report to the investigating officer. Section 53A of the CRPC, which provides for examination of a person accused of rape by medical practitioner, it corresponds to Section 52 of the BNSS. So, according to Section 53A of the CRPC, the examination of a person accused of rape by medical practitioner can be acted at the request of a police officer not below the rank of sub-inspector. But according to Section 52 subsection 1 of the BNSS, the examination of person accused of rape by a medical practitioner can be acted at the request of any police officer. Section 54 of the CRPC, which provides for examination of arrested person by medical officer, it corresponds to Section 53 of the BNSS. Now, there has been a change in Section 53 of the BNSS by the way of addition of a proviso which states that if the medical officer or the registered medical practitioner is of the opinion that one more examination of such person is necessary, he may do so. So, this proviso has been added in Section 53 of the BNSS, which was not earlier mentioned in Section 54 of the CRPC. Section 54A of the CRPC, which provides for identity of a person arrested, it corresponds to Section 54 of the BNSS. So, according to section 54A of the CRPC, if the person identifying the person arrested is mentally or physically disabled, the identification process shall be videographed. But on the other hand, section 54 of the BNSS provides that the whole of the recording process, that is to say, section 54 of the BNSS provides that the identification process shall be recorded by any audio video electronic means. Section 57 of the CRPC, which provides for person arrested not to be detained for more than 24 hours, it corresponds to section 58 of the BNSS. Now the words whether having jurisdiction or not have been added to the latter part of section 58 of the BNSS, which provides that the arrested person has to be produced before the nearest magistrate whether he has jurisdiction or not, and these terms whether having jurisdiction or not were not earlier mentioned in section 57 of the CRPC. Section 61 of the CRPC, which provides for form of summons, it corresponds to section 63 of the BNSS. According to section 63 of the BNSS, every summons issued by a court under this Sanhita shall be firstly in writing, in duplicate, signed by the presiding officer of such court, and shall bear the seal of the court. Now, clause 2 has been added in section 63, which provides that every summons issued by a court shall be in an encrypted or any other form of electronic communication and shall bear the image of the seal of the court. Section 62 of the CRPC, which provides for summons house served, it corresponds to section 64 of the BNSS. Now, a proviso has been added to section 64 subsection 1 of the BNSS, which states that the police station or the registrar in the court shall maintain a register to enter the address, email address, phone number and such other details as the state government may by rules provide. So, this proviso, which has been added in section 64 subsection 1 of the BNSS, was not earlier mentioned in section 62 of the CRPC. Now, section 62 of the CRPC, it did not provide for service of summons by electronic communication, but the proviso to section 64 subsection 2 of the BNSS, it states that the summons bearing the image of the court seal may also be served by electronic communication in such form and in such manner as the state government may by rules provide. So, this proviso has been added in section 64 subsection 2 of the BNSS, which was not earlier mentioned in section 62 of the CRPC. Now, section 63 talks about the service of summons on corporate bodies and societies, which corresponds to section 65 of the BNSS. We can see that the term firms has been added in the marginal heading of section 65, and also the terms director, manager and secretary is used instead of secretary, local manager or other principal officer of the corporation. Now, section 64 of the CRPC, which deals with service when person summoned cannot be found, it corresponds to section 66 of the BNSS. So, the reference to the term some adult male member has been changed to some adult member. Section 68 of the CRPC, which provides for proof of summons in such cases and when serving officer is not present, it corresponds to section 70 of the BNSS. So, subsection 3 has been added to section 70 of the BNSS, which provides that all the summons served through electronic communication under section 64 to 71, both inclusive, shall be considered as duly served, and a copy of such summons shall be attested and kept as a proof of service of summons. Section 80 of the CRPC, which provides for procedure on arrest of a person against whom warrant is issued, It corresponds to section 82 of the BNSS. Now, section 82 subsection 2 of the BNSS, it additionally provides for a new requirement, that is to say that on arrest of a person against whom the warrant is issued, the police officer shall forthwith give the information regarding such arrest and the place where the arrested person is being held to the designated police officer in the district and to such officer of another district where the arrested person normally resides. So, subsection 2 of section 82 has been newly added. Section 82 of the CRPC, which provides for proclamation for person absconding, now corresponds to section 84 of the BNSS. Now, earlier, a person could have been declared as a proclaimed offender only under few sections which have been provided under section 82 subsection 4 of the CRPC. But now, as per section 84 subsection 4 of the BNSS, which states that where a proclamation under subsection 1 is in respect of a person accused of an offence which is made punishable with imprisonment of term of 10 years or more, or imprisonment for life, or with death under the Bharatiya Nagarik Sanhita 2023 or under any other law for the time being in force, and such persons fails to appear at the specified place and time required by the proclamation, the court may, after making any inquiry as it thinks fit, pronounce him a proclaimed offender and make a declaration to the effect. Section 86 of the BNSS, which provides for identification and attachment of property of a proclaimed person, is a newly added provision and there was no corresponding provision in the CRPC. Section 91 of the CRPC, which provides for summons to produce document or other thing, it corresponds to section 94 of the BNSS. So, according to section 94 of the BNSS, besides the production of a document, it also refers to the production of a electronic communication, including communication devices, which is likely to contain digital evidence. Also, the summons may also be issued in any form, that is either in a physical form or in electronic form. Section 105 of the BNSS, which provides for recording of search and seizure through audio-video electronic means, and section 107, which talks about the attachment, forfeiture or restoration of property. These are newly added provisions in the BNSS and there was no corresponding provision earlier in the CRPC. Section 125 of the CRPC, which talks about the order for maintenance of wife, children and parents, it corresponds to section 144 of the BNSS. Section 126, which provides for the procedure for maintenance, it now corresponds to section 145 of the BNSS. So, according to section 145 subsection 1 clause D, where these proceedings can be taken against any person in any district where his father or mother resides. So we can see that clause D has been newly added in section 145 subsection 1 clause D, whereas there was no such provision of clause D in the CRPC. Section 129 of the CRPC talks about the dispersal of assembly by use of civil force and it corresponds to section 148 of the BNSS. So, as per section 129 of the CRPC, any executive magistrate or officer in charge of the police station or in the absence of such officer in charge, any police officer not below the rank of sub-inspector may require the assistance of any male person so that the unlawful assembly can be dispersed where it does not disperse on being commanded to be dispersed. So we can see that here the term any male person has been used. Now as per section 148 of the BNSS, the term any person has been used. Section 130 of the CRPC, which talks about the use of armed forces, it corresponds to section 149 of the BNSS. So, According to Section 130 of the CRPC, the executive magistrate of the highest rank who is present, he may cause the unlawful assembly to be dispersed by the armed forces. But as per Section 149 of the BNSS, the district magistrate or any other executive magistrate which has been authorized by him and who is present, they may cause it to be dispersed by the armed forces. Now let us see Section 135 of the CRPC. Section 135 of the CRPC talks about the person to whom the order is addressed to obey or show cause, and it corresponds to Section 154 of the BNSS. So, according to Section 135 of the CRPC, where the person against whom a conditional order for the removal of nuisance is made, then in that case he shall either perform it within the time and in the manner as specified in the order, or he may appear in accordance with such order and show cause against the same. Now, the terms such appearance or hearing may be permitted through audio-video conferencing. They have been added in Section 154 of the BNSS, which were not earlier mentioned in Section 135 of the CRPC. Section 138 of the CRPC, which talks about the procedure where person against whom the order is made appears to show cause, it corresponds to Section 157 of the BNSS. So, Section 138 of the CRPC, it contains the procedure which is to be followed where the person against whom the conditional order for the removal of nuisance is made, he appears to show cause. So, there has been a change in Section 157 of the BNSS by making the whole procedure time bound. That is to say, a proviso has been added to Section 157 subsection 3 of the BNSS, which states that the proceedings under this section shall be completed as soon as possible within a period of 90 days, which may be extended for the reasons to be recorded in writing to 120 days. Section 143 of the CRPC, which provides for the magistrate may prohibit the repetition or continuance of public nuisance, now corresponds to Section 162 of the BNSS. The words Deputy Commissioner of Police, they are added to Section 162 of the BNSS, which were not earlier mentioned in Section 143 of the CRPC. So now Section 162 of the BNSS reads as follows. That is to say, a district magistrate or a subdivisional magistrate or any other executive magistrate or deputy commissioner of police empowered by the state government or the district magistrate in this behalf may order any person not to repeat or continue a public nuisance as defined in the Bharatiya Nagarik Sanhita or any special or local law. Section 172 of the BNSS, which talks about the persons bound to conform the lawful directions of police, is a newly added provision, and there was no corresponding provision earlier in the CRPC. Hope you all have understood the major changes which have been introduced in the Bharatiya Nagarik Suraksha Sanhita 2023, and in the next video I'll be covering the other changes. So please stay tuned, and thank you so much for watching this video.